they say, they may come and say, yes, I did so, but there was nothing wrong in it, or simply say, yes, I did it. But the matter can't end now because they are saying, no, this is all false. So who will ascertain the truth of the matter?
The Supreme Judicial Council ought to have done that.
My position is.
Now your Lordship is...
Zara mein solution bhi bata dena sir. We're looking for how to solve this riddle.
इसका simple जवाब है sir. जैसे पहले, in some cases it has happened. एक तो ये है जो हमने begin with
नहीं, हमें solution हम आपका point of view समझ गए, हम आपका केस समझ गए. अब हम करें क्या ये बताइए. What sort of order which should not, either then it will amount to the same allegation that you leveled on the other side. The other side will tomorrow complain and say, you never ascertained this fact, and you held that we've done this thing. So, we come up with a solution now.
Yes, my solution is that let this order of the President and the report may kindly be quashed, and a commission may be appointed to ascertain the truth, so that we can cross-examine them, they can cross-examine us.
Commission, how, under what law will we do that?
This honorable court can always do so.
No, they can
to ascertain the truth about the matter.
No, it can't be remanded to the Supreme Judicial Council.
Sir,
is that a possibility or it's not?
It can be, yes. It can be, yes. It can.
No, I want your clear thinking on this.
After questioning the order of
Sub-Article 7, Sub-Article 7.
There is one problem which I see.
एक Sub-Article 7 भी पढ़ लें. 209 Sub-Article 7. 209 Sub-Article 7 पढ़ लें.
जी 7 साहब वो 7 की बात हो रही है ना, तो उसमें है a judge of the Supreme Court or of a High Court shall not be removed from office except as provided by this article. Article क्या provide करता है? President can remove on the basis of a report. The report has to be based on inquiry. So therefore under clause 7
नहीं देखें ये तो admitted fact हो गया that no one ascertained whether the allegation was factually correct or not. That much is established from what I've been able to understand. Unless somebody says, no, it's not been established. I don't think even Khwaja Sahab पूछते थे Khwaja Sahab कहाँ गए?
उनका कोई issue नहीं है.
Was the one way or the other, whether the allegation was true or not, was it been ascertained or not?
It was never inquired into, it was never ascertained, and if that part of the order would
how do we go forward then on this?
We are very respectfully submit.
Because both can't be telling the truth.
No, quite right. May I very humbly submit, no. The order itself may have two components, although they are mixed up. As far as I am concerned, they are mixed up in the sense, one is with respect to the public speech that was made. Whether the public speech that was
made, that's a separate aspect.
This is what I am saying.
That may in itself be such a grave crime that you remove him.
No, I am making a
or nothing implied in the order is the fact that you've leveled such serious allegations against some people
which cannot be sustained because no inquiry was held. That portion.
What is the solution here?
May I very respect, this is what I was saying, madam. May I very respectfully submit the order itself is composed of these two components. One is that a public speech was made. The other is that there was an allegation made or there were some assertions made which were not inquired into, and that was also held against the petitioner. Now that portion cannot be held against the petitioner so far as the STC order is concerned, because that was never inquired into. We are only then left, as far as this list is concerned, only left with the question whether the public speech that was made was
नहीं देखिए उसका बड़े implication होगा. I think let's live in the real world. The entire eyes of the nation are before us. There are 2-3 constitutional offices involved. One is at stake is the independence of the judiciary. if I'm sure you will also agree that no judge should be removed without cause. I'm sure you will say that.
Yes, quite right. That's true.
That's one aspect. The other aspect is there's another constitutional body involved called the Supreme Judicial Council. Now, the Supreme Court should not interfere in the work of another constitutional body unless there is something so manifestly unconstitutional or unjust. What Mr. Hamid Khan Saab is saying is there was no inquiry held, and you are conceding it, and the Attorney General is also conceding it. Needless to say, if the statement made was false, he also concedes that the judge should have been removed. Now, the third issue is the Supreme Court itself. We are hearing this case. Now the question arises, what sort of order we can pass in such circumstances? And I think there's an interconnected, where is the Attorney General? Attorney General, where is he?
मैं ऑफिस से चेक करवा लेता हूँ ऑफिस में
बुला लें अगर उनको.
खान साहब जरा ये ओपिनियन तो पढ़िए पेज 70 पे. ओपिनियन ऑफ द सुप्रीम जुडिशियल काउंसिल.
Yes.
पेज 70 पे.
70 पे. Yes. Conclusion, sir. This council is unanimously of the opinion, kindly see here, that in the matter of making his speech before the District Bar Association Rawalpindi on 21/7/2018, Mr. Justice Shaukat Aziz Siddiqui, Judge Islamabad High Court Islamabad, had displayed conduct unbecoming of a judge of a High Court and was thus guilty of misconduct, and he is therefore liable to be removed from the office under Article 2096 of the Constitution of the Islamic Republic of Pakistan. 2096, which says you inquire into the matter, which was never done. The other portion of this, your Lordship may find very relevant, is on page 4950, where they decided to dispense with the inquiry.
इसमें सवाल इसमें ये पैदा होता है, ये सवाल है कि सपोज एलिगेशन दुरुस्त है, सपोज क्या ये जिस तरीके से एलिगेशन बयान की गई है, जिस तरीके से तकरीर, क्या ये एक जज के लिए मुनासिब था? ये तो ओपिनियन उनकी ये थी कि चूंकि ये कर नहीं सकते थे.
सर इसमें हुआ ये, there was only one hearing camera done, nothing else was ever.
ये तो डिनाइल नहीं आपकी तरफ से कि तकरीर हुई थी.
जी
तकरीर हुई थी, ये डिनाइल तो नहीं है.
नहीं
वो ये
तकरीर का डिनाइल नहीं.
नहीं सर, तकरीर का डिनाइल नहीं.
But देखिए, there are two kinds of speeches, ना? I mean, क्या is a judge not allowed to make a speech?
Yes.
I think we should not forget the facts. The fact is not making of the speech. If it's making of the speech, then probably half the superior judiciary will have to go home, because how many judges have made to the Bar Council's speeches? I mean, these are not two. So
that speech was made before a bar is
no. So it's not a question of mere making of a speech. It's the content of the speech. I think both go together. Now it depends what I say. If I say there should be, I go and tomorrow I make speeches, independence of the judiciary, this, that, the other, fine. I may even canvass a view which is different. But if I make allegation against someone, so I think you can't disconnect the two things. It's the nature of the allegation. Because I would say if otherwise, then we will have to read that Article 19 is not available to judges.
That's what
I mean, okay, you may not agree with the judge's point of view, fine. I mean, but you remove him on that ground. The code of conduct doesn't say you can't make a speech. So on it, I don't think there's anything wrong per se in making a speech. Now, if you make some speech and you launch a vicious attack or loaded attack or whatever you want to call it, that we cannot disconnect with it. We have to see it together. I mean, I can't just say, oh, making of a speech. I mean, making of a speech is your right. Anybody's right.
And addressing,
I mean, it's not exactly.
District Bar Association.
By the way, you may be interested to know the United Kingdom, which is so conservative, judges give interviews. I mean, House of Lords. I mean, those restraints have far gone, and judges of the American Supreme Court, as judges of the Supreme Court, Justice Stephen Breyer and Justice Scalia's debates,
all make public.
Debates were pretty vicious on various law schools they were given. So let's connect it with the speech. Now, nobody's taking us to the next level. What do we do? Can we personally ourselves inquire into the matter?
Sir, one thing which I just want to point out, there were a number of speeches made by Justice Kiani which was published.
I agree with you on that.
Very clearly.
No, I agree with you. It will be, I think it is connected with the content.
Yes.
भाई अगर आपने बिला वजह ऐसे इल्जाम लगा दिए to another I don't want to use the word institution, but it's important,
yes,
whatever department of the government आप कह लें, जो भी आप कहना चाहें. So naturally it is not a nice matter, but if they are true, it changes, I think, the complexion of the matter.
Sir, page 70 अगर देख लीजिएगा, this is
solution मैं आपको ही नहीं बता रहा.
नहीं सर, solution तो ये है कि इस वक्त ये जो order है president का, based upon the report of the Supreme Judicial Council, need to be quashed.
देखें Hamid Khan साहब, it's not so simple. Then we'll be faced with an allegation that the Supreme Court threw Khwaja Saab's clients under the bus and saved one of their own. Again, we have to be very fair to both sides, because you made allegation targeting specific persons. So if we quash it, that means, effectively means that all that you said was true, without an inquiry, one way or the other. Now, how can we, I mean, what do we do then?
So then the answer can be, I'm just making a humble submission, that let this order of the president be quashed, let the report be also quashed, and let the matter be remanded back to the Supreme Judicial Council to hold an inquiry.
Then can this order be passed?
I believe so.
हमें असिस्ट करें.
लेकिन अगर सुप्रीम जुडिशियल काउंसिल बगैर इंक्वायरी के रिकमेंड कर देती है रिमूवल ऑफ
okay, are you saying it's inherent in fundamental rights and due process?
Yes.
Power of remand, can you remand the matter to the Supreme Judicial Council?
That can be consequential on the requestment of the order. It can be.
Khwaja साहब आप क्या कहते हैं इस
There are
पे?
two ways.
नहीं, let's see. Khwaja साहब is a senior counsel. Let's see what his view is. Can we remand the matter to the Supreme Judicial Council, or we can't?
May I very humbly make a submission? It cannot be done because now there is nothing for the Supreme Judicial Council to inquire into, because the petitioner's tenure has already expired. He is no longer, it goes back, he would no longer be a judge to be considered for purposes of removal, which is the function of the Supreme Judicial Council. So it does not fall within the functions of the Supreme Judicial Council at this stage. This is what my very humble submission.
So what is the solution? None?
This matter requires the determination or not?
Let's suppose we, for sake of argument, don't take it amiss, that we set aside the order. That means that that's implied in the order that all that he said, the judge, when he was a judge, was true. So you are condemned. Won't you be condemned?
It doesn't imply that.
Why? Did he say everything I said was true? Therefore the order was set aside?
Yes. What he said, so far as the allegations against specific persons are concerned, they came up for the first time before the Supreme Judicial Council.
No, he's been saying it from day one.
No, he hasn't. The specific allegations against persons, by naming them and naming the incidents also, they never figured in the speech, they never figured in the preliminary reply that was given to the Supreme Judicial Council. It was in the second reply, the additional reply that...
No, but one way or the other, why didn't the Supreme Judicial Council say something on it? They could have asked him, say it on oath,
Yes. What did the Supreme?
I don't know. I called you to cross-examine him. I don't know, whatever way.
I'll make a submission. What the Supreme Judicial Council did was they asked for the then Chief Justice of Islamabad High Court for his reply on the allegations that were made by the petitioner vis-a-vis him, and he denied all those allegations.
But it's one denial.
I'm just making
one assertion.
Yeah. No, but more importantly, may I make a submission? I'd said that before also, and I'm trying to be as balanced.
See, you can't just say because he's Chief Justice, I believe him, and because he's a simple judge, I disbelieve him. That's no.
Now we come back to the speech itself. The sole ground on which the matter against the petitioner could have been sustained, this order can be sustained, is if this honorable court comes to the conclusion that that speech per se was sufficient for his removal because it came within the definition of misconduct.
Are you suggesting a judge cannot give a speech to a bar counsel?
No. What I'm making a submission. May I make a mistake? Irrespective of whether it was true or not what the petitioner said, irrespective of that, because it maligned the judiciary as a whole.
How does it malign the judiciary?
Let's go through the speech itself, if your lordship would.
No,
and it maligned the army institute, the armed forces.
He is maligning you.
No, not in the speech. In the speech, it is the armed forces, it is the judiciary. They are the judges of the Islamabad High Court.
Suppose the allegations are true, then what will happen?
Even then, the petitioner should not have gone public or made a speech before the bar.
Why?
He could have issued a contempt notice.
Why are you saying he should not? Unless you can specify some violation of some law, constitutional provision, or a constitute of the code of conduct of judges, you can't just say he should not have. You should refer to something because of this reason.
The code of conduct says something to
refer to that provision which says that judge cannot give a speech to the bar counsel or
it's
whatever.
Not a question of giving a speech, it is a question of giving a speech which maligns the judiciary.
Exactly, it's the contents of the speech.
Or which maligns any institution in the country. That is
okay. Let us
only that has to be held.
Please refer to the code of conduct. Code of conduct मुझे निकालने. Which provision are you relying upon?
But may I very humbly submit, my lord, I am not taking sides in this case.
No, I know.
Because your lordship has called.
Actually, it's always beneficial to have a senior counsel like yourself.
I'm just
because we are just thinking aloud how to proceed.
Yes.
And we'll be next be calling upon the Attorney General as well. So, which possible misconduct provision can you bring him under?
There's one provision in the Code of Conduct, Hamza, which relates to public speech.
Article 2 up. Maybe you can read Article 2.
I'll read that and then I'll read Article 2 for your lordship, my lord, but I think there's another provision which talks about, this number 5. Yes, it's Article 5. May I very humbly submit? If it is to be stressed, it will fall under Article 5, nothing beyond. I will come back to that also. Functioning as he does in full view of the public, a judge gets thereby all the publicity that is good for him. He should not seek more. In particular, he should not engage in any public controversy, least of all on a political question, notwithstanding that it involves a question of law.
It's not publicity he was seeking. He was, let's call him a whistleblower. Every whistleblower, you will say, is seeking publicity. What publicity he was seeking by this? You are assuming he was seeking. Burden will be on the person seeking his removal to show that he was seeking publicity. It's premised on that. As a judge gets all the publicity that's good for him, he should not seek more. So then it will be you are seeking publicity. In other words, you can't address bar counsels. Yes, there'll be the media there. So what?
Not engage in any public controversy.
No, it says least of all on a it's not the public, it says political question. Where is politics here? There's no politics here.
It states in particular, he should not engage in any public controversy.
So if
least of all on political matters.
Let's take the worst case scenario. If the institution he is in, there is corruption, he should keep quiet.
No. there is.
So what should he do?
He should be writing to the Chief Justice.
Okay, he says failed.
He should be writing to the
failed.
And if there is somebody,
then what should he do? He should keep quiet about it.
If there is someone approaching him, he has the power. He can issue contempt notice to that person. If anybody dares to approach him, to influence him in any of his decisions.
There's corruption, for instance, not this case, we are giving a simple thing.
What I'm saying,
and his colleague is taking a bribe. He writes to the Chief Justice, he informs the Chief Justice, doesn't do anything. He gets frustrated. Okay? Maybe the frustration level comes to a point that I'll go public now. Okay? So, fine, you can, the person against whom he is alleged and himself, you can certainly hold him to task by saying, prove this allegation. And the other person who's alleged it will say, you made a false allegation, I'll show it. Which is exactly what's happened in this case.
But may I
so which other article can you rely upon?
This is the only article, I suppose, my Lord. There is an article which was invoked in the order itself.
Which one was that?
Kindly read second para of Article 2.
I'm going to read that. Right. Second para,
second para of Article 2.
In the matter of taking his seat and of rising from his seat, he shall be punctilious in point of time, mindful of the courtesies, careful to preserve the dignity of the court, while maintaining an equal aspect towards all litigants, as well as lawyers appearing before him.
He should be careful to preserve the dignity of the court.
Yes.
Yes.
This is, my Lord, I think
you are saying it comes under this too?
Lord, what I'm saying is that these are the provisions which can be...
No, tell me which one.
My Lord, I said Article 5 and Article 2, subpara 2 also comes within that because, my Lord...
We have an advantage in having you before us.
My Lord, I'm grateful for
the advantage is... You are now well versed with SJC matters. Okay. The other SJC matters where you are proceeding again. One is finishing a complaint. Right? You don't have to inquire into great details of every frivolous kind of allegation. You can just dispose it off, consign it to the record or whatever it's called. But where are you proceeding against a judge? It's called. Why are you proceeding against a judge? Why you proceed against a judge? With a view to remove him. So you have to give him some. I mean, here you may be conflicted as a lawyer. I'm not saying conflicted in this case, because your contentions at other place may be different. You will say, establish this thing. Fair enough. The burden on whoever lies the burden will establish it or not establish it. It doesn't get established. Clean bill of health.
देखिए आर्टिकल 2 सब इसके सेकंड पैरा में लिखा है टू प्रिजर्व द डिग्निटी ऑफ द कोर्ट। जो एलिगेशन इन्होंने लगाई है वो तो डिग्निटी ऑफ कोर्ट के अगेंस्ट है, तो इसको प्रिजर्व कैसे करें ये आपसे पूछे। उन्होंने एक तकरीर में कर दी। दूसरा तरीका आप बता दें कि कैसे कर सकते हैं।
उसका तरीका मैंने बताया ना, जो एलिगेशन लगा रहे हैं व्हाट इज I again let me reiterate, I'm not taking sides. I'm saying if it can be stretched, that speech and conduct in terms of that speech can be stretched, it could at best fall within these articles, and there's nothing beyond that. Article 5 or at the subpara 2 of Article 2. And this is for this honorable court to decide whether that speech, irrespective of whether it is based on truth or otherwise, comes up to that standard of falls within this mischief or not. That is all. As far as the inquiry part is concerned, that did not take place. So there were, and those specific allegations are not there in the speech. The order itself, when we read page 7, we read the conclusion, it is basically focused on the speech itself, which is said to be the reason why the removal is being recommended. It's not the question of any other issues that were raised there, because they were not inquired into. Yes, to the extent of the Honorable Chief Justice, the reply was sought, and that reply came, and whatever the Honorable Chief Justice said was against what the petitioner was contending.
Did the Chief Justice, was he examined?
No, he gave a letter. So it's all a question. If this is a matter which goes on to inquiry, then yes.
But then it will mean that there must be a standard why you are believing the Chief Justice and disbelieving a judge.
What I'm going back to the observation.
Is it the status which
No, not at all. Not at all. It was just, I am not even supporting that. I am not supporting that because the Honorable Chief Justice said something, therefore believe him and not believe the other part. I'm saying if this Honorable Bench comes to the conclusion that in this matter, irrespective of the contents of the inquiry itself, the speech itself, and that it was made publicly addressed to a bar association, which was then, if this is fine, this is all right, this does not amount to misconduct, then the order that this Honorable Court has to pass, the way to move forward, is to exonerate him of the charges of making a speech which does not come within the ambit of misconduct. It does not imply that whatever he said was true or that it necessarily needs to be.
But if you read the order, it is 39 pages of the order.
Yes.
Content is there. If there was no content there, I mean, I would find it very strange that the mayor making of a speech.
I have submitted, my lord, that in the order itself there is a mixture of the presumption that what was being said by him in terms of allegations were not true, without an inquiry. I've already said that is part of the order itself. Okay. What the conclusion would be then, that this particular list would come to an end with the petitioner being exonerated of the charges, the order being set aside, the recommendation being quashed, and he gets whatever he gets. But beyond that, if this Honorable Court wants to go into whatever
they can,
it has to go out of this list.
Khwaja Sahab, this nation has suffered enough. Now, it's not a question of granting relief to a particular person or withholding a relief from a particular individual. As far as I'm concerned, that's least of my concerns. My concerns are the integrity of the institutions. If the allegation level is true, I mean, the nation wants to know the truth of the matter. This person is telling the truth or that person is telling the truth. You say, no, forget it. Leave it aside. It's not a small matter of a small office holder post. It's a institutional matter. Let me ask you very candidly, as a senior lawyer, would you not want to know the truth of the matter, that the petitioner is telling the truth or your client is telling the truth? Just as you have invested your life in this profession. Yes, would you not want to know the truth of the matter?
This is exactly what I'm saying. I am with your lordship on that.
How do you get to it?
What I'm saying is that not in this list, not in the case before.
So how do we do it?
Then your lordship takes so moto action or takes some other action, but not any. It cannot be.
One इनकी एक तजवीज़ आई है कि send it for review, remand it to the Supreme Judicial Council, that Article 209(7) was not complied with, and 205 and 6 all use the word inquiry, and 7 says you cannot remove it unless you follow the procedure. So that was not done. Without this court determining it, could the Supreme Judicial Council re-examine it and determine it once and for all whether, I think the nation needs to know whether the allegation is true or false. Leave aside your interest and his interest. There is an interest of the nation. You come from an institution which is paid out by the public exchequer. The petitioner comes from an institution which is paid out of the public exchequer. These institutions are not for your personal benefits. They are there to serve the people. So what do we do with it? People will make fun of it. What have you come up with? Result? Who was telling the truth in this matter? Because the truth is diametrically opposed. He's saying one thing, you're saying the opposite. It's not a question of variation of the truth. He misunderstood me, I meant this. Then we could have maybe reconciled both versions. तो ये जरा बताएं, इसको solve करें.
जैसे गुजारिश की, what my learned friend has said, if he has proposed, if he is sticking to that the matter can go back to the Supreme Judicial Council.
Can it? Yeah, but
I see a legal impediment that the Supreme Judicial Council is not cut out, is not constituted, it's not part of the Constitution for the purpose of making an inquiry which does not involve the recommendation made to the President for removal or otherwise of that of a judge. That part of the function has already come to an end.
Are you then suggesting a complaint is filed against a judge, or as in this case by the registrar, whatever you want to call it, without inquiring into the complaint, Supreme Judicial Council says he's removed, recommends to the president, remove him. That's it. End of story.
Oh, the petition is here for the purpose of getting it quashed precisely for this reason.
नहीं, quash की बात तो नहीं आएगी. I'm saying that is the one person, but this is not a matter of one person. It's a matter of the independence of the judiciary, which is with the people of Pakistan have invested into it. They're not interested in a judge serving or not serving. This matter has gone into the public domain now. It has to be, the public has to be satisfied one way or the other. Hey, who was telling the truth? Well, truth doesn't matter anymore. I keep emphasizing on truth. If he's truth, I think all the maslas will go away.
Not just as it was open.
Aren't you personally interested just to know?
No, yes. May I make a submission?
Burning inside you.
But not within the framework of law, within the framework of constitution, yes. We all want to know the truth, absolutely. But we have to remain within the frame. I do not see
which provision prohibits such an order. I'm just thinking aloud.
ये जो केस है आपके पास
नहीं, ये ऐसी जनरल बात कर रहे हैं. अगर एक और कल को केस आ जाए, कंप्लेंट हमारे पास पढ़ने नहीं बहुत सारी पड़ी हुई है, आती जाएंगी, मुझे कोई जज नहीं पसंद, मैंने कहा चलो हटा दो इसको, सारे हमारे जुडिशल मेंबर्स अग्री कर लें, हाँ हटा दो, कोई हम इंक्वायरी करें कुछ ना करें, आपको बस खत्म हो गई बात, अब कुछ नहीं कर सकते हैं.
पिटीशन आती है, एक पिटीशन.
अगर देखिए, एक बात है सब्स्टिट्यूटिंग योर ओपिनियन फॉर समवन एल्स, दैट्स अ डिफरेंट मैटर. The other is inquiring into the matter. Even a murderer has committed murder in front of everybody, you still have to go through the process. I mean, even someone commits murder right in front of 100, 200 people sitting in this room, we can't just say hang him. No, we'll have to frame a charge, we'll have to bring witnesses, we'll have to give an opportunity for cross-examination. Total waste of time, you will say. Yes, that's what rule of law means. Total waste of time. Sometimes it amounts to that. I'm just trying to, each decision creates a precedent. So where should we go now from here?
As I keep saying, my lord, the order gets quashed if dishonorable bench comes to the conclusion
then the nation will hold us accountable.
Necessary, notwithstanding the allegations made.
If you have finished, can we request the Attorney General? Huh?
Yes.
Okay.
I made my submission.
Have you understood, because you came in late? Let's just quickly recap everything. The petitioner made allegations in a speech to a bar. One is, you shouldn't speak to the bar at all, end of story, go home. The other is that the speech was it was not pleasant for someone or the other, and nonetheless it was made. Now the content is either true or false. It is admitted on all sides that the Supreme Judicial Council did not inquire into the matter. The word inquiry, Khan Sahab has said, is finds mentioned twice, again in 2096, and 2097 says you can't remove it unless this. Okay? To proceed further, you have to inquire into the matter, not to finish a complaint. If the complaint was consigned to the record, that's not the issue. But when you are proceeding against a judge, then Khan Sahib has said, where is my due process? Where is my right to, if everybody comes before me asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I am concerned. इसके तहकीकात होनी चाहिए या नहीं होनी चाहिए, बस हवा में उड़ा.
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed, and he has attained the age of superannuation, the matter ends. Now, we were hearing some other case.
Yes.
The same issue came up there also.
So, my lord, as far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition.
Which ouster?
211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
The number of judgments you said doesn't.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this court would have jurisdiction.
Malafide in law.
No, but malafide in law is basically if the process is not followed. If what the law or the constitution requires is not followed, it is malafide in law. Not in fact, but in law. So because if that is so, then this court has jurisdiction. So the court can proceed. The court can look into the movement.
We are not a substitute for the Supreme Judicial Council.
Of course you're not, but the question...
We can't say, okay, now please come and give oath and give it on statement and will cross-examine.
No, this is jurisdictional question. This is jurisdictional question. You're not going to inquire into the matter while sitting as a court. The Supreme Judicial Council's, it is Supreme Judicial Council's remit to look into that matter, but I am just only saying that this court has jurisdiction to hear the petition if the inquiry has not been conducted, 209, and the procedure has not been
crossed that bridge.
So yes. So once that is done,
where do we go from here?
Once that is done, now one fact which was alluded to, and there is a judgment, a two-member bench's judgment in Afia Sheher Banu Zia's case, PLD 2023 Supreme Court 510, wherein the two-member bench has held that if a judge has resigned or has retired, the proceedings, while he was on the bench, had commenced before SJC, they would abate. Now, the federal government, I had in another matter stated before your lordship that the federal government intends to file an appeal against that judgment.
Has it been filed?
Yes, my lord, it has been filed.
What number hai?
My lord, it has yet to be numbered. I hope it will be numbered today or tomorrow. Now, there are several problems with that judgment, and of course,
if the principle of that judgment is sustained, then it effectively cuts both sides. Then a judge who's been unconstitutionally removed can do nothing.
Now, so in this,
in the meantime he retired, for instance,
so in this case,
he attained the age of superannuation.
So in this case, the distinction also is that after the judge the petitioner was removed, he had essayed those proceedings before this court, and he had not attained the age of superannuation at that time. So that distinction being there, but that needs to be revisited also by this bench or any other bench in order for the court to then pass the order of setting aside the Supreme Judicial Council's order in this case. Also,
yeah, I'm not clear with you. Are you saying that we should attach that case with this case?
I would submit so, my lord.
Achha. Okay.
And now, if the inquiry process has not been followed, and the allegation, now we don't know what
is remand permissible?
If, my lord,
if you are saying if Afia is sustained, then it probably may not be. Is that what I'm not understanding?
If Afia is sustained, then perhaps in this case, they may still have to, the petitioner may still have an argument to make, which is that he had not attained the age of superannuation when he had challenged the Supreme Judicial Council's order before this court. So there would be that distinction.
I think there is a fact is that the list in some form or the other was before this court.
That's right. So that's what I was alluding to. That if there would still be a distinction as far as this particular case.
If we accept this petition, what will happen? So we'll simply
two things can happen. If my lords accept this petition and simply set aside the Supreme Judicial Council's order without remanding it, then he would be treated as a judge who would retire.
We are also concerned about the allegations. What would happen to the allegations?
Suppose, with due respect to the petitioner and his counsel, suppose we set aside the order and he is laughing. All that I said was false. Okay? Nation, I think I'm more concerned that every case we decide we have to keep half an eye out. That iska implication generally kya hoga? You may want to do something, but it may have wide ranging implications. The other thing is, doesn't the nation want to know one way or the other? What is the position of the federal government on this? Well, wouldn't you want to, as they say, get to the truth of the matter?
My Lord, so I just got called on short notice, but I know that's not fair. But what I can state here is that now there are certain allegations which are made in this petition, and those allegations, from what I've understood while sitting here, have been denied.
Not some minor allegations, some serious allegations.
Those allegations have been denied, and now obviously this court cannot record evidence. Is not the forum for doing it. Is there a solution? The solution, my Lord, is that in order to look at the entire matter in totality, if Afia Zia is overturned and this matter is remanded to, the order of the Supreme Judicial Council is set aside and the matter is remanded to Supreme Judicial Council, then as far as the inquiry of these allegations is concerned, that perhaps is the only forum.
And then question arises that the man has retired. What will happen?
So for that purpose, you have to overturn Afia Sherbano Zia. For those purposes, you have to first, this court has to overturn Afia Sherbano Zia in order to cross that barrier and then go to
this case. This case is slightly different. He was not retired at that time.
That's right. He was still before the court. Now the question would still be that if the petition is allowed, what could be the consequence? Now if limited consequences
जल्दी डिसाइड हो जाती है इनकी रिटायरमेंट से पहले तो मसला हल हो चुका
वो भी हो चुका होता, बट अगर फॉर एग्जांपल एक ये हो सकता है कि जी पिटिशन आप अलाउ कर दें एंड he is treated as a retired judge and thus entitled to all the benefits which a retired judge is entitled to. But if on a broader scale, so on a broader scale, then I think since he has retired and now that
is what's troubling me. Let's suppose a complaint is filed against a judge 1 month before his retirement. And the Supreme Judicial Council, without saying he is corrupt, Supreme Judicial Council, without inquiring into the matter, recommends to the President, reports whatever, remove him. He is removed. Now, naturally, when he filed the petition, he's already retired.
That's right.
So I don't think the date would there be. He has got no way to vindicate his honor.
There has to be a way.
Basically, you are saying one way is no, too bad. Whether the Supreme Judicial Council inquired into the matter or not. I mean, whether we agree with the findings of the Supreme Judicial, that's a separate matter. One is at least inquire into the matter. Okay, I may have a higher level of proof, another may be lower, but leaving those technicalities aside, basic inquiry has to be conducted of some form or the other.
Absolutely.
I mean, whether it has to be in accordance with the Qanun-e-Shahadat or...
No, it's the Constitution requires so. I mean, a judge cannot be removed without inquiry.
Are judges entitled to fundamental rights or not?
Absolutely. I mean, it is at the heart of independence of judiciary. Absolutely. Absolutely. At the heart of independence of judiciary has
the solution. Kya hai?
So इसका solution to my mind is
कह रहे हैं कि इसको club करें उस केस के साथ
उसको overturn करना जरूरी होगा because that would then settle the law, because in this case obviously there was a substantial period of time when the petitioner was removed.
लेकिन बात कहाँ से कहाँ connect हो जाती है?
And
nobody could have thought this would connect there.
About 3 years.
So if he had 3 years to his service left.
No, like I said, suppose he had only 1 day left.
Yes. So in that hypothetical,
I mean,
then obviously,
I don't think that's really crucial aspect.
So in that hypothetical, which my Lord has just pointed out, I think it is necessary that that point is settled. That the point is settled that even if he stands retired and attains age of superannuation, the matter can still be revisited by
because that delay we are accountable for in this particular case. Because it's proceeded so long. We can't fault the petitioner on that.
Oh, absolutely not. Nobody can.
So, कितनी hearings हो गई थी इसमें?
बेशुमार सर, many hearings.
हमने कितनी दफा सुना?
Last hearing was.
मैंने कहा आपका इल्जाम हम पे तो नहीं है, हमने कितनी दफा सुना इस केस को?
मैं आपको ऑर्डर शीट दिखाऊं तो
ये दूसरी दफा है, हम मेरे साथी याद दिला रहे।
But we are responsible for our seniors.
अक्टूबर 2018 में ये पिटीशन फाइल
2018
नहीं, वो क्योंकि वो पार्टी नहीं बनाया था ना, उसमें भी टाइम लगा। वो आपका कसूर था खान साहब, थोड़ा हमारा कसूर था मगर वो आपका कसूर था, मान लीजिए, क्योंकि आपने एलिगेशंस लगाई थी अगेंस्ट पीपल हु वर नॉट बिफोर अस, सो वी हैड टू गिव देम अ नोटिस। सो वो दैट गोज इन योर, वी डोंट एक्सेप्ट रिस्पांसिबिलिटी फॉर दैट। जी जी।
But the question that even shows that this was a case.
साबिक जज इस्लामाबाद हाई कोर्ट शौकत सिद्दीकी बरतरफी केस की समाअत। शौकत सिद्दीकी के खिलाफ ऑर्डर में तासुर मौजूद है कि उनके इल्जाम दुरुस्त नहीं। हाजा हारिस के ऐसे दलाइल आए सामने।
Have you been following what we are talking about? What is your view? Can it be remanded to the Supreme Judicial Council or not?
But actually, I haven't studied this matter. I wouldn't like to make a comment without going through studying it properly, because it's an important question. But I would say that the Supreme Court of Pakistan is the highest court, and there's nothing in the Constitution which prevents it from remanding the case back to the Judicial Council. But as I said, I would like to study the matter further. Once the matter is before your lordship also has the power to do complete justice under Article 187. So there's no impediment.
आपकी अपील कब लगी है?
My lord, it's been filed earlier today. I think it will hopefully be numbered today. And once it is numbered, I think it can be fixed whenever the office fixes it.
साबिक जज इस्लामाबाद हाई कोर्ट शौकत सिद्दीकी बरतरफी केस की समाअत। रिटायर्ड जज के खिलाफ सुप्रीम जुडिशल काउंसिल में कार्रवाई के इख्तियार का मामला। विफाक ने कार्रवाई का इख्तियार खत्म करने वाले आफिया शेरबानो केस में अपील दायर कर दी है। अटॉर्नी जनरल ने अपील दायर करने से मुतालिक अदालत को आगाह कर दिया।
Any of the council or
This is one of the exceptional cases. Earlier cases like Justice Shaukat Ali's case, there was a detailed inquiry held. And after that, the Supreme Judicial Council submitted to the President to remove him. There have been even earlier cases, Ikhlaq Hussein's case, where inquiry was held. This is the first case of risk nature where no Supreme Judicial Council did not hold any inquiry into the allegations. So therefore, my submission is this goes right against the independence of...
No, can you cite those cases, the earlier cases, where inquiries were held?
One is Justice Shaukat Ali's case is PLD 1971 Supreme Court.
1971 Supreme Court.
Page 585.
585. And here you are saying the Supreme Judicial Council did hold inquiry.
Hold a very lengthy inquiry, some 80 witnesses and so on. So
recommended the judge's removal. And in the next cases, this is Justice Shaukat Ali.
Earlier case was Justice Ikhlaq Hussein's case, PLD 1960 Supreme Court. Yeah, page 26 perhaps.
जी
अच्छा, उसमें
नहीं वो पेज नंबर अखलाक हुसैन हम ढूंढ लेंगे, चलें खैर। अगला वाला बताते हैं, कोई और भी केस है?
ये दो केसेस हैं जहां पर सुप्रीम कोर्ट जज वाज रिमूव्ड आफ्टर ड्यू इंक्वायरी। अब सर एक और बात, 1956 का मैंने कॉन्स्टिट्यूशन एग्जाम देखा है, उसमें कहीं इंक्वायरी की रिक्वायरमेंट नहीं थी एज सच, बट inquiry was held.
Which was that provision of 56 Constitution? Which article?
Earlier article was 128.
128.
60, under the 60.
Article 128, Supreme Judicial Council, which did not specifically mention the word inquiry.
It mentioned inquiry. Article 128 was in the same terms as Article 209. But I'm talking about 1956 Constitution. Under the 1956 Constitution,
किसमें नहीं था?
ये इसमें नहीं था अखलाक हुसैन वाले केस में, स्टेट वर्सेस अखलाक हुसैन।
नहीं, वो कौन सा आइन था जिसके आप जिक्र कर रहे हैं?
56 का।
उसमें नहीं था?
उसमें ये नहीं था कि इंक्वायरी जरूरी है।
उस आइन की कौन सी शिक थी?
उस आइन की शिक थी आर्टिकल 169। 169।
अच्छा, 169। अच्छा, इसमें नहीं था।
हाँ, उसमें अब आप ये I read that out.
No inquiry required. हाँ जी।
A judge of a high court shall not be removed from his office except by an order of the president made on the grounds of misbehavior or infirmity of mind or body if the Supreme Court, उस पर Supreme Judicial Council नहीं, Supreme Court ये function करते थे. If the Supreme Court on reference being made to it by the president reports that the judge ought to be removed on any of those grounds. ये article 169 था उसमें, और इसके बावजूद भी डिटेल इंक्वायरी की गई थी उसमें, और डिटेल इंक्वायरी
ये अखलाक हुसैन का केस था, तो 56 कॉन्स्टिट्यूशन वाज अंडर कंसिडरेशन और द 60 कॉन्स्टिट्यूशन
अंडर द 1956 कॉन्स्टिट्यूशन।
अच्छा, मगर उसके बावजूद भी इंक्वायरी हुई
थी। सो मेरी गुजारिश ये है कि दिस इज द फर्स्ट केस ऑफ इट्स नेचर वेयर ए जज इज रिमूव्ड विदाउट इंक्वायरी. It will have a repercussion for the future because judges of the Supreme Court has no other security available to him except that a Supreme Judicial Council makes inquiry into the allegations. If that is taken away from him, then he is left on the mercy of the person who alleges against him, whether he is president or whether he is any other person making a complaint. So therefore my submission is that a detailed judgment is required to give why inquiry is so necessary in cases where the allegations against the judge of the superior courts for which there cannot be any recommendation for removal without holding a proper inquiry into it and giving a statement of allegations. Even in the case of Akhlaq Hussain, there were 3 allegations, specific allegations made. Similarly, in case of Sheikh Shaukat Ali in 1971, specific allegations were made against him, on which inquiry was held. In here, no statement of allegations were ever given to the petitioner, and naturally,
और भी केस था ना वो खान साहब वाला
जी,
एक और भी केस था ना, वो रिपोर्टेड है या नहीं है?
ये दोनों केसेस तो
फजले गनी खान साहब का कोई उसमें केस चला था या नहीं चला?
चला नहीं था
इनका,
नहीं चला था, नहीं चला। नो
सर। खान साहब एक बात बताएं, आप इसके अंदर तो एलिगेशन डिफरेंट है शौकत अली साहब वाले में और अखलाक हुसैन साहब वाले में। यहाँ पर जो इंफॉर्मेशन की बात है, सब सेक्शन 5 ऑफ आर्टिकल 209, वो इंफॉर्मेशन की बेसिस पे, लेकिन यहाँ तो सुप्रीम कोर्ट ने खुद कॉग्निजेंस लिया है, तो यहाँ तो कॉग्निजेंस लिया है इसने, वहाँ पे इंफॉर्मेशन किसी पब्लिक पर्सन ने, किसी ने कोई इंफॉर्मेशन तो नहीं दी है। तो इंक्वायरी उस सूरत में करी जाए जब कॉग्निजेंस लिया है कोर्ट ने, खुद लिया, रजिस्ट्रार ने दूसरा लेटर भेजा है, बिल्कुल उसकी बेसिस पे, तो ये चीज जो है यहाँ पे जरूरी है, इंक्वायरी बहुत जरूरी, जब कॉग्निजेंस सुप्रीम कोर्ट खुद ले रहा है, और भी ज्यादा जरूरी हो गई है। जनाब ने बिल्कुल दुरुस्त फरमाया, और भी ज्यादा जरूरी हो गई है। हुआ ये था कि ना 1956 कॉन्स्टिट्यूशन में ये केसेस में कुछ एक आध मेरे हिसाब से कुछ करप्शन का भी केस है इसका। जी distinguishable, but I'm just saying the precedent available with us. गुजारिश ये है कि इसमें हिस्ट्रीज की ये है कि ना 56 कॉन्स्टिट्यूशन में विदाउट प्रेसिडेंशियल रेफरेंस किसी जज को रिमूव किया जा सकता था, ना 62 के कॉन्स्टिट्यूशन में ये हो सकता था, 73 कॉन्स्टिट्यूशन में भी नहीं हो सकता। फॉर द फर्स्ट टाइम 17th अमेंडमेंट में ये लाए गए थे, द काउंसिल ऑन इट्स ओन, द काउंसिल में ऑन इट्स ओन मोशन,
ये पहली दफा 2005 में इंट्रोड्यूस किया कॉन्स्टिट्यूशन में कि इवन सुप्रीम जुडिशल काउंसिल विल हैव द पावर ऑन इट्स ओन ऑन द बेसिस ऑफ complaint available can proceed against a judge of the. This is the case here. It is not a case of presidential reference. It is a case with Supreme Judicial Council.
कैसे शुरू हुआ ये इधर में दिखाइए
लेटर रजिस्ट्रार सर दोबारा ये बताएं कैसे
क्या सुप्रीम जुडिशल काउंसिल ने क्या अपने तौर पे ये उठाया या
वो किधर
या रजिस्ट्रार ने एक नोट लिखा रजिस्ट्रार ने किस कैपेसिटी में लिखा
ये अपने तौर पे ना कंप्लेंट है
ये वो दिखाए
रजिस्ट्रार ने किस कैपेसिटी में दी ये भी देखना है
दिखाएं क्या चीज है
उसको
39 पेज के ऊपर है ये 39 पेज पे पैरा 3
2018 को रजिस्ट्रार ने
ये पेज नंबर 39 ऑफ द पेपर बुक
जी सर ये है सर यहाँ पर
अपॉन perusal of the note put up by the secretary of the council
ये नोट किधर है किस पेज पे
नोट नीचे है सर दिया वो पैरा 3 में
आपके कॉपी लगाई आपने एक्चुअल
लगी हुई है
जी कॉपी लगाई इन्होंने खुद भी जो जवाब दिया है रजिस्ट्रार ने
वो दिखा देना एक्चुअल नोट का है
जी सर ये 21/7/2018 ऑनरेबल मिस्टर जस्टिस सिद्दीकी एड्रेस
पेज का है पेज कौन
ये पेज 39 पे सर
नहीं ये तो उसका रिप्रोडक्शन है ना
रिप्रोडक्शन है
मुझ में एक्चुअल नोट दिखाइए मुझे
एक्चुअल नोट हमारे पास तो नहीं है ये हमें तो
ये रिपोर्ट से डॉक्यूमेंट फाइल किए इसमें क्या है सारे ये जितने
अब उन्होंने जो
ये सर 73 पेज पे एक लेटर है अरबाब मोहम्मद आरिफ साहब का
जी
कंप्लेंट अगेंस्ट मिस्टर जस्टिस शौकत अजीज सिद्दीकी जज इस्लामाबाद हाई कोर्ट ये 31 जुलाई 2018 का है
जी हाँ
आई एम डायरेक्टेड टू सर्व अपॉन यू द एनक्लोज ये तो बाद में है ना
कंप्लेंट जो इन्होंने रिसीव की है वो 23/7 की है जो रजिस्ट्रार ने कंप्लेंट
वो मेंशन किया उसको रिप्रोड्यूस किया हुआ है पेज नंबर 39 पे पैरा 3 में रिप्रोड्यूस किया हुआ है
जी हाँ बिल्कुल सही एग्जैक्टली वो रिप्रोड्यूस किया देन the note put up by the registrar and the transcript of the speech note जो है
ये नोट
हाँ ये note on top of page 39 on 21/7/2008 Honorable Mr. Justice Siddiqui addressed District Bar Association Rawalpindi during this speech he said
39 के शुरू में
page 39 सर
ये पैरा 238 से शुरू हो रहा है
page 39 के ऊपर जो फर्स्ट पैरा आप देखिए
नहीं वो तो एलिगेशन है ना
जी एलिगेशन है
अच्छा नीचे पैराग्राफ 2 से पढ़िए
सर ये पैरा 2 on page 38
जी
on 23/7/2018 the secretary of this council registrar Supreme Court of Pakistan submitted the following note before the chairman of the council chief justice of Pakistan ये वो फिर नोट 23/7 को रखा गया on 21/7/2018 Honorable Mr. Justice Siddiqui
no he was acting pursuant to a direction of the Supreme Judicial Council or my lord has asked Justice Jamal has asked that he did it himself. एक तो ना you do it. One is he does it, comes before the Supreme Judicial Council.
So it doesn't say so much, but it appears that there was some kind of.
We will go by the Constitution. Constitution says the council on its own.
On its own.
Secretary is not the council. He may be complainant.
It may.
He's part of the. He's part of the Supreme Judicial Council.
Maybe the council had directed him to do it. I don't know.
Nothing is on record कोई चीज नहीं है
ठीक
लेकिन ये मतलब उसने अपनी पर्सनल कैपेसिटी में दिया
आप ये हियरिंग जो अच्छा एक चीज बताइए
आप जनाब पढ़ लीजिएगा
कितनी दफा सुप्रीम जुडिशियल काउंसिल में ये केस लगा आपका आप कितनी दफा सुप्रीम जुडिशियल काउंसिल ने आपको तलब किया
एक दफा only on one occasion.
What happened on that occasion?
On that occasion we said that